there was some implication that maybe there was an ongoing business of Premier being operated at that facility. I don't see that allegation. If there was, I don't think it's consistent with the allegation of the complaint that they were locked out for 2 months before the stuff got taken. I think it's reasonable to interpret it as Judge Pedinow did, which is these were goods that were in storage and that they were taken either accidentally or on purpose. And as we know, the duty to defend requires the carrier to defend the entire case if there are alternate allegations. Just like in a shooting case, I either accidentally shot you or I purposely shot you. If there's a negligence count, the carrier has a duty to defend. You asked what Judge Pedinow, really what his analysis was. That's what it was. What it was is there are negligence counts in here. These are real negligence counts. These are not fake negligence counts, because a reasonable interpretation of this complaint is you had permission to take this pile of stuff. You either accidentally or on purpose took this pile of stuff. That's a negligence count in the alternative.
And your position is that action constitutes accepted for storage?
Correct.
Okay.
Correct. Yes, Your Honor.
Because the allegation that they had, they were directed to go in. They were directed to go in, so they had permission to go in and remove.
They were directed by somebody. There's no allegation that they broke and entered, or that they entered impermissibly, or that they didn't have permission to take these other third-party goods.
Yeah. The suggestion, I think, is that the landlord, invited them in to
clear it
get
out.
These things out.
I think that's a reasonable suggestion. I frankly hadn't thought of it until you said it today. But, what the allegation, and that's consistent with the allegations of the complaint. It's also consistent with the negligence count on the part of the people that were directed under a totally valid contract with the landlord, given proper permission to enter and take the stuff out of the storage thing. That still makes it a negligence claim.
We don't know what the landlord asked them to take out, do we?
We don't even know the name of the landlord.
I know.
It's not even alleged in there.
Well, did they want everything out, or just the military's things, or military and Premier's things, or they wanted it all because they considered it all Premier's,
and they're going to sell it against the rent?
I
mean, who knows? But these questions that you're asking are exactly the questions that the trial lawyer for Van Liner wanted to ask in getting discovery before the summary judgment. And his argument was, we should have a right to prove that this was all intentional. And Judge Contino said the right thing, which is, this is a coverage case. Defend your insured. Go prove it wasn't intentional in the underlying tort case. Get your insured out, and then you're out. That's what his analysis was. So we would ask the court to affirm. Thank you.
Thank you.
May it please the court. The underlying complaint says in paragraph 12, it was during the transfer of such third-party owned property that Hunt removed the personal property belonging to plaintiff as referenced in Exhibit A. So there was
Why isn't that accepted for storage or for preparation for shipment? Why is she wrong about that?
That's not acceptance. That's talking about transfer of third-party property. Transfer is an entirely different coverage. That's under coverage B. Coverage, coverage A, as I said before, talks about goods which have been accepted for storage or preparation for shipment at the premises of the insured. So when
I think her point was that at the premises of the insured that part of your argument wasn't preserved because, frankly, in your brief, you don't even include that in your quote from the policy. And the first time that's raised is in the reply brief, is that right?
I thought it was raised in the initial brief, but even if it's not.
Well, I've been looking for that language, and I don't see it because you ... after shipment.
Even without that language, though, you still have to have goods which have been accepted for storage or preparation for shipment. And transfer of property is not acceptance for storage or preparation for shipment. Transfer is what happens under coverage B, which counsel has agreed today is not what they're looking for. Coverage B is where you're talking about transport of goods of customers. They're talking here goods that have been accepted for storage or for preparation for shipment. And that certainly, under the plain meaning of, and plain interpretation and plain wording, is not transfer of third-party owned property And then looking at paragraph 13, Hunt did not have permission to remove plaintiff's personal property. If you don't have permission to remove personal property, you certainly have not accepted goods for storage or preparation for shipment. And the allegations are identical as to first class in count, I believe it's count 5. It's the same wording, it just substitutes names. So we believe the court read terms and conditions into the allegations of Premier's complaint that are not there, and read terms and conditions into the van liner policy that are not there. The allegations of the complaint given their fair, normal, customary meaning, and the allegations of the van liner policy, when given their fair, normal, and customary meaning, does not mean, well, we took your goods and we're going to wrap them up and we're going to transport them, and during the transport of the goods to do something with them later, that's part of storage. That's not what storage is. The policy very plainly says that it's either goods which have been accepted for storage or for preparation for shipment. And that's not what's alleged. They're alleging during transfer of property of someone else, Premier's goods were taken. We ask the court for a reversal of the summary judgment and directions to enter judgment in favor of van liner. Thank you.